Hello, everybody. My name is Timothy Scott, or TJ Scott, and I'm an estate planning attorney and the owner of the law office of Timothy J. Scott. And what being an estate planning attorney means is that I get to help people to protect their families from court and conflict if they become incapacitated or if they die. And it sounds really dark, but in truth, I really love it. I'm able to help people. I'm able to help their families. And in truth, I really see myself as a peacemaker at heart, with the ability to keep people from having to and keep families in particular from breaking apart because of conflict in between them. So again, I'm really happy to have everybody here with me today. We're going to be talking about something that I know is a difficult topic for a lot of people, but I also believe that knowledge is power. And today I really want to empower you. I want to educate you and give you some peace of mind around this difficult topic so that you can bring that back to your family and live a more intentional life with your family, knowing that you've already got this taken care of. Today, I have some valuable information to share with you, and also some offers that I'm going to actually be sharing at the end of this presentation. And that's why I encourage you to be present with me today. It's the best way to learn. Be here with me today. Turn off distractions. If you have other windows open in Chrome or something like that, I encourage you to take the time that you've set aside today to learn about this topic, and just set those things aside. They'll still be there later. Angry Birds will still be there later, and just come here and be with me right now. And I always say your future self is going to be glad that you took the time to be here and learn with me. I see somebody posting, I'm 59, wife is 58, starting hospice this week. It's devastating. She's refused to talk about will or future plans. What can I do to help her prepare for her death in 1 month or 2 months? That's something that I'll talk about here today. And again, it really brings up the fact that I know this is a difficult topic, and I know that this is something that is really hard to talk about and hard to hear about. And again, I'm going to try to empower you. I'm going to try and empower you in ways that you can talk about this that aren't just about fear, that are about how can we keep the peace in the family? How can we make sure that everything is good for our family? So again, I really appreciate you posting that. Again, that's devastating, and my heart goes out to you who shared that with me. As I said, if you stick around towards the end, I am going to have some very valuable offers that I want to make to you. And the first one of those is a free virtual one-on-one meeting with me, where we'll talk about everything that you have and everyone that you love. And we'll talk about how you can protect them and make sure that the plan that is going to be enacted for them is a plan that you choose, so that you can control it, and you don't have to worry about the state's plan being enacted on your family. Plus, I have a bonus gift that I think you're going to like to see, and it's going to make it even easier to get a personalized and tailored estate plan done for your family. But just to start here, I'd kind of like to find out from people, do you have an estate plan? And so I'm going to launch a poll here. And if you see the poll, if you could go ahead and choose one of those options that are displayed. Do you have an estate plan? And so I've listed some items, some parts of an estate plan on the screen here. Things like a trust, a will, guardianship, nomination, all the way down to beneficiary designations are really parts of an estate plan. None of that is the whole thing. In order to have a really good estate plan, you have to have each of those parts. And we'll talk about all those parts today, and we'll talk about exactly what they do and what they benefit your family. Right now, I'm seeing it looks like most people do not have an estate plan in place. And I have to say, I hear that a lot. 69% of people do not have an estate plan in place. And there are a lot of reasons that I hear for that. And in fact, let me put up a poll here and find out what people's reasons are if they don't have an estate plan in place for not having one yet. You can choose more than one option in this poll, but maybe you're too busy, and you don't just feel too busy, maybe you are too busy. And I totally get that. As a father of 3 and somebody who owns their own business, the law office of Timothy J. Scott, I really understand when people tell me that life is busy. Life is busy, and it's busier and busier and more hectic and frantic than ever before. But if that's the case, I want to commend you again for taking the time to be with me here tonight, because I know it's not easy. I know it's difficult to take the time away from family, to take away the time from work and relaxation. And so again, thank you for being here with me tonight. And maybe you feel like you're too young. And honestly, anyone over the age of 18 should have some kind of estate planning documents in place. And the people that I help, I will often put a healthcare directive and a power of attorney at least in place for their kids, so that their kids who are over 18 as they go to college, because it's really important. It's really important to have somebody named in case something happens, so that that person can take over. And a lot of us don't realize this, but once our kids turn 18, they're out on their own, and we can't be the person who gets to make healthcare decisions for them. We can't be the person who gets to make financial decisions for them unless we have some kind of permission from them, something like a healthcare directive or financial power of attorney, something like that. So anybody over the age of 18 should really have something in place. But maybe your objection is that it's too expensive. And I will tell you, before word processing, estate planning really was only for the wealthy. But more and more today, estate planning is not just for the wealthy. Estate planning is for everybody. Everybody who wants peace in their family after they're gone can find a way to get an affordable estate plan put into place that's really going to take care of their family and make sure that there's not court and conflict there. Or maybe you're worried about jinxing yourself. I'm not saying anybody say that they're worried about jinxing themselves, which, I mean, that's good, because I will say, I've been doing estate planning for a long time, and I've never seen a correlation between somebody getting an estate plan done and having something negative happen to them. In fact, I always say my clients, I think, tend to live more intentionally after they have their estate plan done. It's like a weight lifted off of their shoulders, and I see that relief on their face a lot of times after we get it done. And so I tend to think that that there's more. You're able to live life more fully after you get your estate plan done, and you shouldn't have to worry about jinxing yourself. Okay. If you have a plan in place, and I think there are some people here who do have an estate plan in place, what is it that you want to learn today? And even if you don't have an estate plan in place, if you see something on here that really jumps out to you, I hope that you'll flag that for me as well. Maybe you want to know, is an online will okay? One of those wills from LegalZoom or wills.com or something like that. Is that going to work for me? Is it going to take care of my family in the way that I want it to? Something we're really going to be talking a lot about today. It's something I want to get really clear on. Maybe you're wondering if your plan is outdated. Maybe you don't have minor kids anymore, but the plan that you have still lists guardians for those minor kids because you just haven't updated it in a while. And I get that a lot. I have a lot of people who come in and that's the case for them. And we need to get everything updated and make sure that that it matches the current law as well as the current reality in their family and the current reality in their assets. And maybe you just want to get a better understanding of estate planning in general, or maybe you want to get a better understanding of the estate plan that you had written for you in the past. And again, we'll be talking a lot about that. And we'll be talking about the ins and outs of estate planning and what you really need to know and what you really need to look for to make sure that you're getting an estate plan that is going to take care of the people that you love. The reality is you're in the right place here today. You're in the right place if you have something or someone that you care about and that you want to protect. And you're in the right place if you've done an online will or fill in the blank will, or you're considering doing an online will, but you're kind of concerned about whether or not it's going to work for you and do what you want it to do. And you're in the right place if you're nervous about how much this is going to cost. And that's something that I deeply understand. Concerns about the expense, concerns about the cost of getting an estate plan done. And I promise you that I will be speaking towards that. I will be telling you exactly what fees I charge, in fact, in order to get an estate plan done with me a little bit later today. But the reality is the estate planning that you do isn't about you. And that's really true to me. It's something that I really realized when my wife and I were updating our estate plan. And these are my three kids from left to right. It's Margaret, Ben, and Elizabeth. And when we were updating our plan, we really realized that we weren't ever going to enjoy our estate plan. It wasn't going to make us money. It wasn't going to enrich us, other than the fact that we knew that we had an estate plan in place for the people that we love. And we knew what was going to happen if we couldn't be there with them anymore. We knew what was going to happen if we became incapacitated. We knew what was going to happen if we died, and who was going to be able to raise those kids and what assets they would be able to use in order to raise those kids. So it was really a burden off of our shoulders. But like I say, it was really for them. It wasn't for us that we were doing it. And so these are the kinds of things that we're going to cover today. We're going to talk about planning for incapacity. And we're going to be talking about who can make healthcare decisions for you if you needed someone to make healthcare decisions, who can make financial decisions for you if you needed that. Again, planning for incapacity means planning for if you were in a car accident and you were in a coma, or if you had early onset dementia or late onset dementia if you're older, or Alzheimer's, something like that, where you aren't able to function completely by yourself anymore. And you need some help. You need somebody to step in and help you with those kinds of decisions. We'll also talk about planning for when you pass away. And it's a sad fact, but we're all going to die someday. And it's something that we can embrace. It's something that we don't have to be scared of, because we're all going to die someday. And we know that. We aren't fooling ourselves that it might not happen. But planning for when we pass away, we need to start thinking about things, especially if we have minor kids. We need to start thinking about guardianship. We need to start thinking about things like probate, which I'll talk about in depth in a little bit. But probate is a court case. It's a court process that your family has to go through after you're gone. That's expensive, takes a lot of time, and is also public. It's not a fun process, but that's what it is. We'll talk about estate taxes, and we'll talk about Minnesota's estate tax as well as the federal estate tax. We'll talk about unclaimed property. That's something that a lot of people aren't aware of, is the fact that there is unclaimed property out there that people lose after they pass away oftentimes. And we'll talk about what that is and where it can be found again. And we'll talk about intangible assets, things like your stories and your values and how you can share those as well. Somebody else is mentioning, my dad set up a special needs trust for me with my sister as trustee. My mom is still alive. Is there any way I can change the trustee? That's a really fantastic question. And it really depends on the provisions written into the trust. Oftentimes, I will include provisions in my trust that allow the beneficiaries to choose a new trustee if they're unhappy with the trustee that they currently have. And so, and so that is something that I could help and review for you if you were interested, and take a look at exactly what that says and help you with that. But really, it's going to depend on the provisions written into the trust and what it says there. Okay. So before we get started and before we launch into talking more about estate planning and more about those provisions that I just talked about, I'd like to share just a little bit about you so that as we're here tonight, you know a little bit more about me and about my family. So this is me with my wife, Tobin. That's her name, Tobbyn. And these are our three kids. And this time from left to right, it's Elizabeth, Margaret, and Benjamin. And we live in Bloomington, Minnesota. Ben is our oldest. He's 9 years old. Elizabeth is 6 and Margaret is 4. And they really are my whole world. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class. And the very next day, my first child, Ben, was born. I found a job with a small estate planning law firm, and we did estate planning. We also did tax preparation. And I loved the clients that I was able to work with. But at the same time, I didn't always feel like I was serving my clients in the way that they completely deserved. I didn't feel like I was giving them the full value of what I thought they deserved. And so after a little over 3 years, I actually ended up leaving that law firm. And this is a picture from my last day there at the office. Someone has to graduate at the bottom of the class. Now, I have to say, this was not said about me. This was actually something that my parents said about a really extremely negative experience that they had with an estate planning attorney who helped my grandmother. And in particular, I remember my mom saying this: someone has to graduate at the bottom of the class. But in truth, I'm not sure that that attorney actually was that dense, or actually did that poorly in their law school learning. I think that they learned lessons that led them down kind of a wrong path, a traditional estate planning model path. And I will talk about that a little bit later, about how a typical estate planning attorney is going to be planning for death, really. But your estate plan can do so much more than that. It can really plan to enrich your life as it is now. Somebody saying, I have a healthcare directive complete for my wife and self. Youngest is 21. Assets are IRA and joint accounts, and home and joint names valued at 480,000. Should I remove wife's name before her death in the next few months? That is really going to depend on your circumstances. Generally, no. But we should talk about that, and that's something that is going to be very fact specific, and it's going to be very very dependent on what is currently going on. If there are some possible reasons that it might make sense to do that, if there are some kind of special needs going on, where she's not able to interact the way that she used to be able to, or if you're trying to qualify for some government benefits, that sort of thing. But it's really a very contextual question that I would need to know more about the context and more about the facts. And I'm really happy to discuss it with you offline in more detail. So actually, I didn't ask. Let's get a picture of kind of what the demographics are of everyone here today. So if you see another poll pop up, if you can let me know if one of these, what is the best one that describes you, which of these categories best describes you. I'm seeing married with young kids, single without kids, single with grown kids. I'm seeing, it looks like we've got kind of a mix all throughout. And I see somebody saying that they don't see a poll. Yeah, and I don't know why that is. I don't see you listed in my the number of attendees that I have either. So I'm not sure what's happening, but I'm glad that you're able to interact via the chat. So if you just want to put in the chat what best describes you, that would work too. And again, if you're single, if you have kids, if you don't have kids, if your kids are grown, if you are married without kids, married with young kids, married with grown kids, that's really the different demographics that I'm trying to weigh. And so thank you everybody for weighing in on that. And I can see not everybody here has kids, or not everybody here has minor kids, but if you'll bear with me for just a second, this is just so important to those people with minor kids. And in particular, if you have a family member or a friend who has minor kids, this is something good to discuss with them, or good to tell them about this. So short-term guardianship. What is short-term guardianship? Well, the best way to think about it is if you think about the kids being home with a babysitter and there's no plan in place, and for whatever reason, mom and dad don't show up. What is that babysitter going to do? Eventually, that babysitter is going to call the police, and they're going to get Child Protective Services involved. And this is really protection for the police, because they don't know who can take the kids. They don't know if they can go to a neighbor and have the kids stay with the neighbor. But that's risky for the police to put them in the hands of somebody else without having clear legal documentation saying that they can stay with that other person. And so it is really important that you have guardianship documents in place that say, this person can stay with my kids, whether it's a family member, whether it's a friend, somebody who can stay with the kids, so that you don't have to worry about that Child Protective Services taking over and having your kids go to stay with Child Protective Services. And I don't mean to rag on Child Protective Services, because I think that they do the best job that they can. But I can tell you that I don't want my kids to ever have to spend a minute with Child Protective Services, and I've done planning to make sure that they won't. Long-term guardianship, on the other hand, is who is going to raise your kids until they're 18 and until they're able to be out and on their own. And the reality is that there is a plan out there. And the plan, even if you haven't written a plan, is out there for you. And that plan is that a judge is going to decide which unfortunately means it's probably a plan that you're not going to like. And so you know where your kids are going to thrive. You know who ignites passion in them and who helps them to flourish. And so it is almost always the best for the parents to choose that guardian, to choose that long-term person that they can stay with and that can raise them until they're 18 years old, to really make sure that they flourish, make sure that they thrive, and make sure that they are able to take on the world in the best possible way. And that is very possible with long-term guardianship nominations. Seeing somebody else weigh in, 59, married, 35 years, wife in hospice. Yeah. Youngest twins, 21. Nice. Thank you again for sharing that with me, sharing those details about your life with me. So how will the people that you love receive your assets under your current plan or the state's plan for you? And the state really does have a plan for you. Minnesota has an estate plan called probate, and it's a court process. This is true across all 50 states. The state's plan for you is called probate. And what probate is it's a lawsuit that you have to file against yourself with your own money for the benefit of your creditors. It's not a good thing. But your creditors want to make sure that they get paid. And so they have created this, Minnesota has created this, well, every state has created this process called probate that has some really terrible features because it's a one-size-fits-all process. So this is the process that Prince's estate has to go through. It's also the process that estates with more debts than assets, so more money owed out than money in the bank, those estates also have to go through this probate process, which just makes it a mess. So if there's no estate plan in place, this is the plan for you. But what a lot of people don't know is if the plan that you've written, or if the plan that you're considering writing is a will-based plan, then that also needs to go through probate. And there's this really geeky phrase or geeky saying that we have in the estate planning world that says, where there's a will, there's a probate. If you are planning with a will-based plan, then you are going to have to, your family is going to be subject to probate later on. And some things about probate that people really don't like. Probate is slow. In Minnesota, probate takes a minimum of 6 months, more often 12 to 18 months to get through. And even though we'd like it to go faster, it just can't. There are certain slowdowns intentionally built in to make sure that creditors have enough time to come forward and get paid. Not to mention it's working with the court system, and the court system is often overwhelmed. And so working in that system, there are going to be slowdowns. There are going to be times that it's really difficult to keep moving. And this is just what happens. Probate's also very costly. And we'll have an opportunity in just a minute to actually estimate what probate might cost for us. But there are attorney's fees and executors' fees, appraisers' fees, all kinds of fees all over the place, to the point that probate in Minnesota is generally estimated to cost somewhere between 3% and 6% of the gross value of the estate. So that's the fair market value, the gross value of the estate. And so you can imagine if all that you own is a house worth $400,000, even if you have a mortgage on it, the fact that the house is worth $400,000, probate will already probably cost somewhere between $12,000 and $24,000 to get through. Big chunk of that will be estate planning or the attorney's fees, the probate attorney's fees. But again, there are a lot of other fees that are built in there, including court fees that just can't be avoided and are going to cost a significant amount to get through that probate. Probate's also public. And so here you can see the last will and testament of Anna Nicole Smith. And wills have to be filed with the probate court in order to initiate the probate process. Also that has to be filed in the probate court are things like an inventory and a final accounting. And that means if there are predators out there who are looking for someone who is young and maybe impressionable and who has received an inheritance recently, they can actually go down to the probate court and access the inventories So that lists all of the assets in the different probate case, as well as the final accounting to see who is receiving those assets and in what amount. And so again, there are predators out there. Unfortunately, that's the world that we're living in right now, and they can access this information to see exactly what your heirs might be receiving out of your estate. Finally, and worst of all, if you have kids who are under 18, or if you just have kids in general, even if you have grown kids, they would be entitled to your assets outright without any restriction at 18. And I can tell you, I thought that I was a pretty mature 18-year-old. My mom kind of disagrees when I bring this up to her, but I think I was pretty mature. And I can tell you, I would have bought a Corvette if I had received a big inheritance. I would have bought a Corvette and I would have driven around really fast in it. That's just what I would have done. That's where my head was at when I was 18. Unfortunately, that's where a lot of 18-year-olds' heads are at. And so it's something to think about is how mature should somebody be before they're able to receive an inheritance? And when is it going to negatively impact their life versus positively impact their life? Which is something that is really important to think about. All right, so somebody is asking, probate, does it occur with a spouse death or both die and pass assets to children? Spouse law in Minnesota is what? And this is a fantastic question. Generally, what I see almost across the board is that spouses will own property jointly. And so that means things like checking accounts, a joint checking account. The home will often be owned jointly with joint tenancy, it's called, with right of survivorship. Other things that can be owned jointly, brokerage accounts are often owned jointly. Vehicles are often owned jointly. And so for all of those things where you have joint ownership of the items, when one of the spouses passes away, the other spouse continues their ownership. They inherit the other half of the asset from the spouse without having to go through probate because it was owned jointly together. And so when I'm talking about probate, I'm talking about things that I'm talking about when both of you pass away and you need to pass things down to your kids. But I'm also talking about if there is separate property that's owned. And this can often happen with an inheritance, for example. It can often happen with a small business, that those are often owned separately. And so if there is a bank account, if you didn't merge all of your bank accounts and there's a separate bank account out there that either you own or that your spouse owns, that bank account could be subject to probate. There's another process that you can follow in Minnesota if the assets are worth less than $75,000 and there's no real estate. But if those assets that are owned separately are worth more than $75,000, you can end up having to go through probate. And in fact, that's true for somebody that I'm helping right now, that one of the spouses passed away, but they had some separate assets that they were holding at the time. It was a separate bank account. And that separate bank account was big enough that it is going to push us into probate even while their spouse is alive. And so even though that probate may not reach the house, which was owned jointly, it is needed in order to successfully manage this bank account and make sure that it gets into the right hands. And so that's a really good question. But generally in Minnesota, we have separate property laws for spouses. And so property is generally treated as separate unless it's deemed joint. And oftentimes, if you open a bank account with your spouse, the most common way that I see bank accounts are joint. The most common way, almost without exception, that I see homes is joint tenancy with right of survivorship if two spouses own that home. But again, if it's owned separately, then you may be looking at a probate for those types of items. That is a really fantastic question. So here's an opportunity to actually calculate your probate estate. And what I've done here, I've listed some assets that would be subject to probate, things like the family home, a rental home or a cabin, furniture, household goods, automobiles, stocks, bonds, bank accounts, and a business interest. All of these types of assets could be subject to probate. Again, if they're not owned jointly, assuming that you're the second one passing away, or the second spouse is passing away. And so what I've done here is I've added up to get the gross total of the estate. And then you can get 5% of that number really quickly. And I love this trick. I found this trick. Somebody taught me this trick at one point. What you do is, to get 5%, you just move the comma over one place. And so you see that makes it 85,000. And then you divide that number in half, which is 42,500. That's how I got that estimated probate costs and fees. That's estimating it at about 5%, which, as you remember, is within the range of 3 to 6% of the gross value of your estate. And that 3 to 6% number is what probate is generally deemed to cost in Minnesota. To add a little wrinkle to this, if you own life insurance, or if you own retirement accounts, and that life insurance or those retirement accounts are payable to a minor, then those assets also have to go through probate, because you can't have someone under 18 who is able to take the proceeds from a life insurance policy paying out, or able to hold on to the payouts from a retirement account. And so you need to bring those items through probate. So you can see how that affects that estimated probate cost. All of a sudden, it really skyrockets when you have a life insurance policy and retirement accounts. But the good news is there actually is a foolproof way to avoid probate, and that's by fully funding a living trust. And so a living trust is a document. It's an agreement that you write between yourself, and yourself, if you can believe it. Yourself as the creator, yourself as the person with control, and yourself as the person who's able to benefit from the trust. And so you write this agreement, or an attorney really writes it for you. An attorney should be writing any revocable trust, because it's complicated and there are a lot of provisions to understand and a lot of provisions to really wrap your head around. But you write this trust agreement, and then you fully fund it by doing things like retitling investment accounts in the name of the trust, going down to the bank and signing new signature cards so that that bank account is now in the name of the trust, or you're holding it as a co-trustee of the trust, or a sole trustee of the trust. Executing deeds to real property, transferring stock and bond certificates so that they're in the name of the trust, assigning personal property, either with an assignment of personal property or a bill of sale document that puts that personal property into the trust, and then changing life insurance and retirement account beneficiary designation so that they actually point to the trust after you pass away, and so that they don't go directly to somebody who might be a minor, might not be able to handle the asset, but can actually take the asset, and you can dictate, you can control what happens with it when the person that you love would receive it. I have another question here. Can you go to the county to check how the house is owned? I'm pretty sure joint, but how do I check? Better to have her sign off before death or not? I am the guy that cannot see the polls, wife in hospice. Okay, great. So yes, you can go down to the county. You can go to the county recorder and pull the deed for your house to see how the house is owned. And what you're looking for is the language joint tenant, or joint tenancy, in joint tenancy. That's really what you're looking for. It's also something that I have access to, a way to pull it. And so I kind of hope that you'll just reach out to me, and I can help you with this, and I can help you check this. Better to have her sign off before death or not? Generally, no. If it's owned jointly, there's not a great benefit to having her sign off before she passes away. If it's owned jointly, it's going to come to you automatically by force of law. And so the thing to be looking for after that is if you pass away shortly after she passes away, that asset could be going through probate, which is what we just talked about, and end up costing your estate a significant amount. Another question here: if wife has months to live, better to wait on making a living trust or try to do now, knowing she will die within months? And that's a really good question. It's a question that, again, that I'd really like you to have. I'd really like it if you'd bring it to me either in a phone consultation or in a full virtual one-on-one meeting where we can talk about the ins and outs of it and why it might be beneficial to do that planning now, even though I'm sure things are really hectic right now and things are really difficult. But there is planning that you can do, even if she's not willing to engage in the process, because if I remember correctly, I don't think that she was interested in moving forward and engaging in the process. But there's planning that you can do to make sure that you are protecting the people that you love. And so if you are the second one to survive, if you're the last one to survive, even if you pass away shortly after she does, everything would be protected, everything would be taken care of for the people that you love, so that they'd be able to receive in the way that you would want them to receive. So again, a really good question. And again, I hope that you'll connect with me after this so that we can talk about that in a little bit more detail. So here's an opportunity to calculate your estate tax. And this is where I get to give everybody really good news. Estate tax is not what drives most estate planning. Estate tax does affect some people, especially in Minnesota, where we have a lower estate tax exemption. But generally, most people are doing estate planning for things like avoiding probate, making sure that they have control over how the people that they receive are going to receive. And there are a myriad of other reasons that people are doing estate planning, but it is good to know where your current assets might put you in the estate tax picture. And so on the federal level right now, there is an estate tax exemption of $11.7 million. It is astronomically high right now. And in fact, you can actually double that number to $23.4 million if you are married, because you get $11.7 million for the first spouse who dies and $11.7 million for the second spouse who dies. In Minnesota, the exemption is lower. The exemption is $3 million. Again, this doesn't affect most people, but there are some people that this does affect, and it's something that you need to be aware of and you need to plan for if you're getting close to that $3 million number. In Minnesota, the exemption does not automatically double. It can be doubled if you do some estate planning, and in particular, if you put some trust that will kind of leap into being upon the death of the first person, and you hold those assets in a separate trust after subjecting them to the estate tax and under the estate tax exemption, they are shown to not have to pay estate taxes. It's a complicated thing to talk about, but the gist of it is, if you're getting close to that $3 million number, you really need to talk to an estate planning attorney to make sure that your heirs aren't losing up to 16% of the value of their inheritance to estate tax. Will your assets be lost to the state? And so here I'm talking about the Minnesota Department of Unclaimed Property. And does anyone have an idea of how much is in the Minnesota Department of Unclaimed Property? And I'm not going to keep you in suspense for long. There's over $700 million right now in the Minnesota Department of Unclaimed Property. And across the United States, that number is even bigger. There's over $58 billion in the departments of unclaimed property for the various states across the United States. And the way that that happens oftentimes is that somebody passes away and their heirs, the people that they love, their family, wasn't aware of all of the assets that they had. They miss a bank account, they miss some stock, they miss something that that person that they love had when they passed away. And so, this is happening more and more frequently nowadays that we have electronic statements turned on, and we're not even receiving those paper statements to the house that actually tell us what our bank account balance is, because that's how we used to find, when we would do probate, that's how we used to find accounts, is we would go through the deceased person's mail and we would look for statements and we would look for different records showing what kind of assets they owned and where those assets were. And so now with electronic statements, like I say, we're seeing even more and more that is being lost to the Minnesota Department of Unclaimed Property and the other unclaimed departments of unclaimed property. And so it's really important that you put something in place where you are actually creating an inventory. You're actually making sure to go through and list where all your assets are. Otherwise, it's possible that you could lose something and that it wouldn't go to the people that you would want it to go to after you're gone. This is really cool. You can actually make your estate plan a real gift to your kids by including something called asset protection. And this is something that they can't give to themselves. Technically you can, but it costs tens of thousands of dollars. And honestly, it doesn't even work all the time the way that you would want it to. So asset protection means that the inheritance that you give to your kids can be protected from things like divorce, can be protected from things like creditors and lawsuits in case something happens. And again, this is something that is really cool that I am able to build into the estate plans that I write. And if you're interested in this, if you want to know more about this, I hope that you'll reach out. So I have somebody saying that that they have significant assets right now, and their spouse is likely to die within months. And so there's might be some need to pass things to the kids now to avoid the Minnesota estate tax in particular. Best to give traditional IRA. Again, you're asking for some real specifics. Reach out to me. We can do some planning. We can take a look at this and we can figure out what would be best. And I'm really happy to do that. I know life has got to be really hectic for you right now with everything that's going on. But go ahead and reach out to me. Schedule a time on my calendar when I post it, either for a phone consultation. I'm happy to talk you through questions like this. I'm happy to give you guidance through in a phone consultation or in a one-on-one virtual meeting where we can really get into this in depth and talk about it. But I can't give you guidance on the best way to gift assets to kids in this setting. I just can't. It's there are too many different factors at play, and there are too many different things about the context that I really need to know. And so I hope that we can connect after and really talk about this question, because it's a very good question, and I understand that the need for you is very real right now. So this is something that is a little intimidating to talk about in the midst of everything that's going on right now. Talking about planning for incapacity, planning for healthcare decisions, and who can make healthcare decisions for you. And if I imagine that there are some people here who remember the person on the screen, this is Terry Schiavo. And Terry was a person who was in a vegetative state, and her family had different ideas of what would be best for her. Her parents wanted Terry to be kept alive, but her husband didn't think that that's what Terry would want in the state that she was in. Terry's husband really thought that the plug should be pulled and that Terry should be allowed to go peacefully. And so there were court battles in Florida and all across the United States, including all the way up to the Supreme Court, fighting over Terry and fighting over what should happen to Terry and who should be able to make that decision. And the fact is, if Terry had named in a document that I created called the Healthcare Directive, if she'd named what she would have wanted for her healthcare, those fights could have been avoided. That conflict could have been avoided, and especially the conflict in her family, and the court cases that really dragged us all into the drama in her life and in her family's life, could have been avoided because she could have made it clear exactly what she wanted. So talking about all of these things, talking about probate, talking about estate taxes, talking about healthcare directives and guardianship, talking about all of these different things that we've talked about today. What can you do today to do the right thing for your family, and what should it cost to plan in the right way? So really your options to create a plan, if anything here tonight has really resonated with you, if anything here tonight is something that you would want to avoid, then you really have a couple of options. You can either write a plan for yourself, you can do it yourself, or you can work with a lawyer, and keep in mind that not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer, or should you do it yourself? And the truth is, if you own more than just your personal belongings, if you own more than just cars, clothing, furniture, furnishings, jewelry, if you own more than that, if you own your home, if you own significant bank accounts or investment accounts, if you have significant retirement accounts or a business interest, if you have a big life insurance policy, something like that, then you would really benefit from working with an attorney to make sure that you are able to pass those things along in the right way. And if you want to ensure that the people that you love stay out of court and conflict and have someone to turn to when something happens to you, then you don't want to risk doing it yourself. You want to work with an attorney who can really assure you, who's been there, who's seen it, who's seen the outcome of the estate plans that they've written. You want to make sure that you're with somebody who can really guide you through the process and really take care of you to make sure that your estate plan does exactly what you want it to, which is keeping your family and the people that you love out of court and conflict. If you want a kids protection plan, which again, I know not everybody here has minor kids, but if you want that short-term guardianship, long-term guardianship, making sure that those kids are taken care of in every different context, or you want to avoid probate or estate taxes, or you want to protect your children's inheritance in that asset protection trust that I talked about, then you have to work with an attorney in order to get those things done. Those things are just not available otherwise. You just have to work with an attorney in order to get that done. And if you want to guarantee that your plan is going to work for your family when your family needs it, then you really have to work with an attorney. And what this brings up for me, the truth is I am a huge do-it-yourselfer. And it was just a little over a year ago, I was getting the fishing rods ready to go fishing with my son. And I was putting fishing line on one of the fishing rods. And it was, honestly, it was one of the first times that I had done it. It had shipped without fishing line, and so I needed to put it on. And just when I got done and I went to snip the line, all of a sudden, the line started unraveling from the reel and just shooting off of the reel. I don't know if I wound it on the wrong way or if I wound it on too tightly or too much of it. I don't know exactly what I did wrong, but I can tell you I ended up with a tangled mess of fishing line all over the place. It was a screw up, and I goofed it up, and that's okay, because I was able to see right away that I had made a mistake. I was able to see that my do-it-yourself project didn't turn out the way that I wanted it to. But all that I lost was like, $3 of fishing line, not a huge deal. And I was able to see immediately that there was a problem. That is not a luxury that we have with estate plans. When there's a mistake that's made in an estate plan, we don't know that that mistake is there until it is too late, until you're gone, until your family is dealing with the repercussions. That's when we learn that there was a mistake in the do-it-yourself plan. And that's why I feel really, really strongly about this. And admittedly, I'm biased because I'm an estate planning attorney. But keep that in mind, that if you do it yourself, you're not going to know. Only your family is going to know. Only your family is going to find out later whether it worked the way that you had hoped that it would work, or whether there was something that was wrong and something that your family is going to need to sort through and fix and take care of. Just an added point. If you want to give your assets to someone other than your kids, if you want to include charities, if you want to include, if you don't have kids and you know that you want them to go to a niece or nephew, sibling, something like that, then you should really work with an attorney and make sure that those provisions are written in the right way so that they get to the people that you want them to go to. So you've probably made your decision now about whether you want to try and do it yourself or whether you want to work with an attorney. And that's great. But again, not all attorneys are the same. And I want to bring you back to this quote again, that was not said about me, but that my parents said about an estate planning attorney and an estate planning attorney experience that they had, that my grandmother had worked with before she passed away. Someone has to graduate at the bottom of the class. And this is a sentiment that is held about too many estate planning attorneys because they're practicing in a very typical traditional model, which again, I call planning for death. So that typical experience is writing form documents that are kind of set it and forget it type documents that they bring you in, they size you up for a certain plan, they plug your name into a form document all throughout, and they don't really explain it to you. They don't really explain why they did things in the plan that they did, but it's just a form that they are used to filling out, and they print it off and have you sign it, and you bring it home and you stick it in a desk drawer, and you don't look at it again for years. that is the typical experience. That is an experience that was very real to me when I was working at the small estate planning law firm that I was working at. And it's a system that does not serve clients in the way that they need to be served. It does not serve people. It does not serve your family in the way that they really need to be served. Typical experience also isn't going to keep money out of the Minnesota Department of Unclaimed Property. It's just not something that estate planning attorneys generally think about. They don't think about whether all of the assets can be found. And honestly, it's not a real concern for them, because if assets can't be found, that's not malpractice. That's just real life, that there was a mistake made and some assets couldn't be found. It's not really any skin off the attorney's nose. But I don't think that's a good attitude for attorneys to take. I think that attorneys can ensure that things aren't lost to the Department of Unclaimed Property, and that all of your assets go to the people that you want them to go to. And I think this is especially important for people who have limited assets, who don't have millions and millions of dollars in assets that are going to go to the people that they want them to go to. But if you only have a select amount of assets, and you are going to really want to make sure that those get to the people that you want them to go to, so that they can enjoy what you're able to give them. Typical experience may avoid probate, but may not. And I'll tell you, this was very real for me, that a lot of the planning that we did in the small estate planning law firm was intended to avoid probate, but was not successful. And again, that's not malpractice. That's just common practice, that oftentimes things would be missed. Things wouldn't be funded into the trust in the right way. I told you how important funding everything into the trust is. And that's something that I talk about with my clients a lot and in a lot of depth. It's very important, but unfortunately, it's not always overseen by the attorney, and it's not always done in the right way. And so oftentimes probate ends up being necessary, even if you've written a trust, even if you've gone to a typical estate planning attorney who's written you a trust, just because there's a lot more to writing an estate plan, and there's a lot more to executing an estate plan than just writing the document in the right way. Typical experience probably doesn't keep your family out of conflict. Typical experience is only going to focus on the money. It's not going to focus on things like your stories and your values, which I'm able to capture in a way that I'll share with you in just a second. So the typical experience leaves assets to heirs unprotected without that asset protection trust that I talked about. It's just not something that the typical attorney is familiar with. It's not something that they typically use. Typical experience is not going to provide ongoing legal guidance. In fact, it's going to be hourly fees, and you're not probably going to ever want to contact that attorney again when they've finished charging you their hourly fees and kind of nickel and diming you for things that feel like they should be included in the price of what you've paid them. The typical experience is not going to adequately protect the kids. It's not going to take care of them in that short-term way, in that short-term guardianship way. And it might deal with the long-term guardianship, but oftentimes that's done in a way that's really substandard as well, and requires a will to go through probate in order to actually be effective for the nomination of those guardians. But really, that typical experience, that typical estate planning lawyer planning for death experience, is going to leave you with the question: is this going to work when I need it to work? Is this going to work for my family when my family needs it to work? And that isn't the way that it should be. Planning with me is completely different. And I call it planning for life. Even though, let's be honest, we're planning for incapacity and we're planning for what happens after you're gone. But it's a totally different experience from that traditional, typical experience. For one thing, I only charge flat fees. And in fact, I even let you choose the fee. And that doesn't mean that I just rely on your benevolence to choose a fee that will make sure that I get paid and make sure that I am able to keep a living roof over my head, or whatever the saying is. But you'll be able to choose a fee and choose a package that both matches with what you can do financially, as well as what you want to do for your family. Planning with me keeps your money out of the hands of the state. I create an inventory that makes sure that nothing is lost after somebody passes away, that we don't lose any assets to the Department of Unclaimed Property. Planning with me is also going to protect your kids totally, both in the immediate and the long term. It's going to keep your family out of court and conflict. And I think that is so important. Keeping family out of court and conflict. Again, really at heart, I am a peacemaker. And I know that subjecting your family to probate court when everybody is grieving, or subjecting them to unclear documents and unclear guidelines about what should happen when everybody is raw and grieving, is one of the best ways to create conflict and to have a meltdown in the family. And again, at heart, I'm a peacemaker, and I don't want to see that happen. I don't want to see that happen in your family. Planning with me means that you're going to know that you've made the right decisions. Because again, I really believe in educating and empowering my clients, and I will guide you every step of the way and in every different provision of your trust or of your estate plan, so that you completely understand what everything does and how it all functions together, and why we need the things that that I've included in that estate plan, or that we've included, decided to include in that estate plan. Planning with me also means that you can protect the family money from outsiders. You can protect that inheritance with an asset protection trust, which again is a really fantastic gift that you can give to the people that you love. And planning with me means that you're going to have a lifetime of guidance and protection. You know that you can pick up the phone and call me, and I'm not going to be charging you hourly fees for having a conversation. If there are big changes to your estate plan in the future, if there are changes that are going to require a significant amount of time, and I can't say whether there will be or not, and you probably can't say whether there will be or not either. And that's why I will have to charge for changes to the estate plan in the future. But picking up the phone, answering emails, answering your questions, there will never be a charge for that. I don't charge for those types of things, because we need to have open communication between us. We need to have lines of communication open, so that you can tell me when things change in your life, and I can tell you when things change in the law, and we can talk about how that's going to affect you and how that's going to affect your family, in order to make sure that your plan really works when you need it to work. Your plan is going to work when your family needs it, if you plan with me. And really, it's a gift that you give to the people that you love the most. And I do see there's a question here. I will be speaking to that in just a moment. But I want to keep covering what I have here. So I told you that I would be talking about the expense. I told you that I would be talking about the cost. And again, stick with me. There is an offer that I'm going to give you in just a minute that will even help with this cost some as well. But I want to set some context here first. So if all that you have is a house worth $400,000, then doing this estate planning will save your family at least $12,000. And the way that I got there is I just calculated 3% of that $400,000 house. And I calculated what probate likely would cost. Probate would likely cost more than $12,000, honestly. With just one asset like a house, generally you can expect to be towards the top range of that that gross probate amount. But really, you can expect to save at least $12,000 by working on an estate plan if all that you have is that $400,000 house. If you have assets worth over $3 million, then this planning is going to save your family at least 13 cents for every dollar in excess of $3 million. Again, it's that estate tax and saving your family from having to pay that estate tax bill from their inheritance. A typical death plan with an estate planning attorney who is operating in that typical traditional way is going to cost a minimum of $1,500. And honestly, that's been ticking up as well lately. And you can be almost guaranteed that it's not going to keep your family out of court and conflict. It's not going to ensure your assets aren't lost to the State Department of unclaimed property. It's only going to cover your money. It's not going to cover your kids' immediate care, nor your values, insights, stories, and experience, your most valuable and intangible assets that are often the most lost assets. The alternative is you can meet with me. I'm a personal family lawyer, and that means I take a very personal interest in the estate plan and in our work together. I work very closely with my clients as a personal family lawyer. And you can learn specifically what your family needs. And again, you can choose your own fee, which the range of my fees is between $2,000 and $8,000. And you're going to know that your plan is going to work when your family needs it to work, when you're not there with them. And again, I really want to make this easy for you. I'm going to go ahead and post the link to schedule with me right here. You can see the link down there at the bottom. You can also find the link in the chat box, and you should be able to click on it there so that you can get to my calendar and see my calendar there. But I want to make this easy for you. I want to include that first virtual meeting with me. It's a 2-hour-long virtual meeting where we'll talk about everything that you have and everyone that you love. And we'll talk about what would happen under the estate's plan for you, or if you have an estate plan in place already, we would talk about what would happen under your current estate plan. And I will tell you exactly what's going to happen, and I'll tell you exactly how you can take control and change the way that the estate's plan is written for you. I want to give you that meeting, that 2-hour-long one-on-one meeting with me, absolutely free. It's worth $750 because the amount of time that it takes and the amount of energy and expertise that I bring to that meeting. But again, for you, I want to do that for free because you've taken the time to be here with me tonight and to educate yourself on this topic. I also want to give you $250 off the estate planning package of your choice if you do reserve your appointment before the end of the week. And when I say the end of the week, I mean the end of the day on Saturday. If you will go to my booking link and book a family wealth planning session with me before the end of the day on Saturday, I'm very happy to give you that $250 off towards the plan of your choice. And really the reason that I do that is estate planning is a momentum thing. And right now you have built up a lot of momentum to get an estate plan done. It's hard. I know that it's hard. It's hard to talk about. It's hard to think about. But you've built up the momentum. You've been with me here tonight, and I want to help you to keep that momentum going. I think that's part of what I do. I'm kind of, in part, a coach who helps you keep the momentum going and helps to keep you going so that you get an estate plan done and that you don't falter and end up without having an estate plan done. And so I want to give you that $250 off. If you don't book before the end of the week, that's okay. You can always book in the future. I will still give you the family wealth planning session free. You just won't have that $250 towards the plan of your choice if you book in the future. But I'm going to keep up with you. I'm going to send you some newsletters that include tips and tricks about estate planning that are really good to know. I'll also send you invitations to future webinars that I'm doing in future in-person events, because I'm going to be hosting some in-person events here in the near future as well. If everything stays okay, if everything stays the way that it should, and that we all hope that it does. I will keep up with you, but keeping up with you has a cost to me, and it has it takes energy in order to keep up with people. And that's why I want you to book that family wealth planning session with me tonight, so that you'll be making my life easier so that I don't have to keep up with you and keep following up with you and checking in on you and seeing where you're at in the process. I want you to keep the momentum going. I want you to take advantage of these offers and get your estate plan done, because your family really deserves it. Your family really deserves to have everything taken care of after they don't have you anymore. And so those are your next steps. To schedule your free family wealth planning session using that link that's in the chat. Is anyone having a hard time finding the link, anything like that? If you are, please let me know. Please let me know in the chat or the Q&A, or raise your hand or do something so that you can signal to me that you're having a hard time finding the link. And then after you've booked your family wealth planning session with me, go ahead and use the $250 towards the plan of your choice. I am seeing that somebody is saying that they haven't seen the link. Let's see how I can get that to everybody. Everybody can see the link on the PowerPoint, correct? It's obviously not ideal. Well, let me see if I can post it into the chat box again. Are people able to see the link? I have it posted out to panelists and attendees. Everybody should be able to see it there and be able to click on it as a link there. That's my hope. Otherwise, you can just type it in. You can type in tjslawoffice.cliogrow.com/book. And if you click there, you'll be able to see different ways that you can get in touch with me. You can start with a 15-minute consultation if that's where your comfort level is, if that's what you feel comfortable starting with, or you can jump in and book that family wealth planning session where we can get together in a longer format and really be able to talk through all of the things that you have and all of the people that you love and make sure that everything is taken care of. Again, I do see some questions here. I do have somebody is raising their hand. And so I don't know if you want to talk, I can let you talk. Otherwise, if you're just having a hard time seeing the link, maybe that's why, because I think I did say to raise your hand if you're having a hard time seeing the link. If you have a question, if you want to be able to talk, please put it into either the chat box or the Q&A so that I can see it there. I do have some questions that I'm going to start answering here. And so if you're the person raising your hand, go ahead and put it into one of those boxes so that I know exactly what it is and I can speak to what you're saying. But I have a question here. How about ongoing changes like more assets like farmland coming up in the next 5 to 10 years from Iowa and Nebraska? Part will be in a trust and part not in a trust. How to add new farmland? And that's a really good question. Adding new assets, adding additional assets to a trust is not difficult. And what it really involves is just retitling the farmland like you're discussing into the name of the trust. And we can include provisions in that trust that talk about what to do with farmland and what to do with that kind of agricultural land and make sure that those provisions are included when we draft the trust or draft the estate plan in the first place. Let's see here. Can I do the first 15 and then the 2 hour? Yes, absolutely. That's perfectly fine. If you want to book now or book both right now so that you can secure that $250 towards the plan of your choice, I'd encourage you to do that. But yeah, absolutely. You can feel free to connect with me for a phone consultation before booking or before going into that full 2 hour session, because I know you probably want to know a little bit more. You probably want to get a feeling for me and a feeling for how I operate and who I am. It's hard to tell over a webinar like this where it's just me talking the whole time. But it's easier to tell if we do something like a phone consultation together. So I encourage you to do that. If you want to know who I am, if you want to know a little bit more about me, get a better feel for me and get a better feel for how I can help you in your situation, then yes, absolutely. Feel free to sign up for a 15-minute consultation and the family wealth planning session as well. My mom is 88. She refuses to complete a will or trust, said we can deal with issues after her death. Stated house, 260,000, farmland in Iowa, 500 to 800,000. What would probate take Iowa? Need help moving her to do something. Man, that's a really tricky issue. So if your mom, my understanding is that your mom is currently living in Minnesota in a house worth 260,000, but that she also owns farmland down in Iowa. And what that means is that 2 probates would have to be opened. There'd have to be the probate here in Minnesota, which is the general probate or the main probate. There would also have to be an ancillary probate that is opened in Iowa. And I can tell you the cost of having to open 2 probates to having to open a main probate here and an ancillary probate is going to be expensive. It's going to be more than 3 to 6% of the gross value of the estate in order to get that done. And so it is a really tricky question. How can you get somebody to plan who doesn't see the need to plan, who doesn't feel the urgency to plan? And there are a number of ways to do that. You can connect that person with me and I can talk to them. I have a number of frankly difficult stories about people who did not get an estate plan in place and now are having to go through and deal with the consequences, or their families are having to go through and deal with the consequences of not having an estate plan in place. It's more than just having to go through probate. Probate is rough. Probate is expensive. It takes a lot of time and it really grinds on the family. It grinds on the cohesiveness of the family and causes conflict in the family. It's really difficult. And I have seen families break out into open conflict, not armed conflict or anything like that. Thank goodness, not yet. but I have seen the conflict that it can bring into a family, and I have seen the way that families can fight because of that, and because of having that. And so talking to your mom about that might help her to move her to do something. If she cares about your family, if she cares about your cohesion and your ability to stay together and continue communicating into the future, that's something that's good to talk to her about. That everybody is going to be grieving when she's gone, and she is probably somebody who holds the family together. And so, at least that's the case in my family. Is that my grandmother was really the person who held the family together, who brought us together for different events. And so when something happened to her, the family fell into conflict and really fell apart. And we didn't get to see my family for a really long time because of that conflict, because of the hurt from dealing with that bad estate planning plan that she had in place. And it was really difficult for the family. And so that's something that you could say to help her to do something. Other things, you can show her what the costs of probate are going to be. And you can ask her, is this what you would want to have happen to your assets? Is this what you would want to have happen? Would you want it to go to an attorney? Would you want it to go to the court system? Would you want it to go to making sure that your creditors are paid before anyone else? Are these things that you would want to have happen with your estate, or would you rather have something else happen? Would you rather make sure that it gets to the people that you want it to go to, while still remaining in complete control during your lifetime? Because I know that that's a concern for a lot of people. A lot of people are concerned that doing an estate plan means having to give up some kind of control during their lifetime, and that isn't true. You don't have to give up control during your lifetime. You can still have all of the control over your assets. You can still have all of the control in your trust and over the trust agreement and everything by when you complete an estate plan. That's something that not everybody feels comfortable with, or not everybody understands, but it is the case that you can have complete control. And so talking to her about that and ensuring her that you can maintain complete control. You can avoid expensive processes like probate, and time consuming and conflict inducing processes like probate. You can make sure that the people that you love stay out of conflict after you're gone, and that they're able to stay cohesive and stay together. Talking to her about that, if you feel comfortable talking to her about that, I really encourage you to do that. It's important. But I know it's hard. I know it's hard to have that conversation as well. And so if it's a conversation that you'd feel comfortable pointing her to this webinar, it's something that I do repeatedly. If you feel comfortable with that, I'd be happy to present this information to her. I'm also happy to share this information. I'm happy to share this webinar and links to past webinars that I've done, if that's something that she would watch or something that she would engage in. I'm also happy to have a 15-minute phone consultation with her and just talk her through exactly what it would look like for her and what it would look like for her family when they lost her. I'm happy to do all those things. So let me know how I can be of service. One question that I often get is, what does the family wealth planning session look like? And again, I've said it can be totally virtual, but it's an opportunity for us to get acquainted, and it's an opportunity for us to talk about important things for your family and for you and for the people that you love. Things like, who would be the person to collect everything for you if something happened to you? And would they be able to find everything? Do you have everything gathered somewhere? Do you have a file folder somewhere in the back of your filing cabinet? Or do you have a file on your computer that maybe it's a spreadsheet or something like that on your computer that has all of your information on there? We'll talk about that, and we'll talk about alternatives and how you can keep that information in a really secure way, but also in a way that it can be found and that it can be used by the people who come after you when it needs to be used. We'll also talk about what will happen when you become incapacitated, and we'll talk about how you can make decisions about what your healthcare would look like, as well as who could help to make sure that those healthcare decisions are made in the right way, and who would be making financial decisions for you. We'll talk specifically about what probate would look like for you and for your family, we'll be talking about going through and talking about exactly what that process entails. It's a process that I've been through a number of times, and so it's something that I can talk about in length. This is what I've seen. This is what I haven't seen. This is what you want to look out for and why you want to avoid it. We'll also talk about estate taxes, and we'll talk about ways that you can minimize the amount of estate tax that you might have to pay towards the state or towards the Fed if you're getting to that point where you're starting to owe towards the Fed. And we can talk about, how do you want the people that you love to receive the assets? Is it good for them if they receive the assets at 18 or at 20 or at whatever age that they're at right now? Do you have any concerns about special needs in your family? And that's something that's really big right now. Is I know that there are a number of the population who have special needs and who have government benefits and government help in taking care of them and in ensuring that they're able to live in as autonomous and live and function in society in the best way possible. And so there are government benefits that can be put into place that will help with that will help pay for rent, pay for food, that type of thing. And so if you have somebody that you love who's receiving special needs or who has special needs and is receiving that type of government benefit, it's very important that you make sure that any inheritance that they receive is received in the right way. Because if they receive that inheritance directly, if they receive it outright, it can actually knock them off of the government benefit that they're receiving. And they would have to private pay for what they're paying for, and that they would have to actually reapply down the road for that government benefit again after they've been kicked off of it, which can be really frustrating. It can be really time consuming and difficult for people. But also, if you have people in your family who have issues with substance abuse, or if you have people in your family who you know that their relationship is kind of rocky or difficult, then you might have special concerns about how they receive the assets. And that's something that we can really talk about in depth in a family wealth planning session. And we can talk about the dynamics of your family, and we can talk about who's likely to fight, who's likely to be a leader and be a helper and take control, and who would take control in a negative way, and how we can prevent that person from taking control and ensure that they aren't given free rein to overrun the rest of the family. If anyone else has any questions that they'd like to pipe in, I'm happy to take those. Otherwise, I'm just gonna share with you about some of the other things that I've heard in the past that are really important. One question that I often get is about nursing home care and about the expenses of long-term care. And it's something that's on a lot of people's minds. It's something that I can help to give you some ease about, that I can help to talk to you about and present some options about how you can pay for nursing home care in different ways, in creative ways, while still protecting the money that you want to have your kids inherit, that you want to be able to pass on to them. And I can answer questions about who can oversee the money and who should oversee the money, and what that person looks like, and what features that you really should be looking for in that person. I'm not seeing any other questions coming in right now. I've answered a few tonight, and I really appreciate everybody who's brought me questions, because I love to be able to answer those. It's generally, if you have a question, it's a question that someone else on the line also has. And so, so I really appreciate everybody who is able to bring those questions to me. It looks like people have been able to access, at least some people have been able to access that the scheduling link. I do see some people scheduling appointments with me, which is fantastic. I'm really looking forward to being able to meet with you and help you help you get clear on everything. I will be sending out the link to schedule with me, as well as the link of this webinar later tonight. So do look for that. Look for that in your email box, and you'll be able to see that. I'll have this webinar posted to YouTube, and you'll be able to see it there. Again, the deadline for for qualifying for that $250 bonus towards the estate plan of your choice will end a day on Saturday. And so I hope that you get your family wealth planning session scheduled before then, and that you're able to take care of that offer. Other than that, I want to thank everybody for joining me tonight. It's really been a pleasure having you with me. Oh, I do have one question coming in here. Need to have my mother hear from you to be willing to set up will or estate. Do you do phone calls on Saturday if I travel to her house? And yes, go ahead and connect with me. I believe that you are already going to be connecting with me, and we can find a Saturday that's going to work. But yes, absolutely, I'm happy to take some time on a Saturday to connect with somebody that this is a priority to. I'm apologize. I think I clicked allow to talk to somebody, and you did not ask for that. So, all right. Thank you again for joining me tonight. And it's really been a pleasure having you here, and a pleasure to be able to talk with you and to answer your questions. Again, I hope that we can meet in person soon. I hope that we can be able to continue this conversation and work through whatever it is that's brought you here tonight. Feel free to reach out to me if you want to book an appointment. I would love it if you want to reach out by email or by telephone. I'd be happy to answer any questions that way as well. Anyway, I hope that you all have a good rest of your night. Take care. Bye.